right, so tell me what we got this morning. Ms. Settles, Mr. Spiesman, what do we got this morning? I got it pulled up now.
Your Honor, we are here on a motion for contempt that was rescheduled from May 2nd. The respondent was supposed to be getting a psychological evaluation and supposed to provide pregnancy test results. We still have not gotten the actual pregnancy test results. We continue to get just letter correspondence from a doctor's office that states when she went, what time she went, all of that. But we don't have that confirmation. We have gotten a psychological evaluation. I have some issues with that as well. Payment has been made as was supposed to happen with the compliance with the first protective order, but we are still running into the issue of Ms. McMahon just not being held accountable for her actions. It sounds like she just, after the May 2nd hearing, she continued to text and reach out to the new girlfriend of Mr. Steinfeld, who is Maria, and I gave her the Zoom link, so she should be in here shortly. And she is my witness for today, but one of my witnesses for today outside of my client. But she continued to receive text messages. She got emails to her work email. She's still was reaching out since the date of the protective order. So today we are looking for Ms. McMahon to be held in contempt. To be held in willful contempt and to have to pay attorney's fees for her contempt.
All right, Mr. Spiesman.
Thank you, Judge. If you recall, this case initiated and originated from a TPO, Judge. We consented to the TPO, and we also agreed to pay approximately $12,000 in attorney's fees, which from my humble perspective was to try to resolve all of this and put these challenges and difficulties behind us. I don't think I've ever agreed to pay that type of money in my entire career for attorney's fees, but we recognize the exposure and effectively agreed to it. During that time, Your Honor, Mr. Steinfeld was represented and then not represented and then represented by other lawyers. So I had some direct contact with him. And there was a clear distrust in anything that I'd say or do. That being said, there was an order to provide a psych eval. We did that. I think it's completely disingenuous that anyone would contest the validity of that psychological evaluation. And frankly, my client would concede that she has mental health challenges without a shadow of a doubt. In addition to that, Judge, we have provided proof of a miscarriage directly from the OBGYN, and Mr. Steinfeld and Ms. Settles continue to claim that that's not sufficient. Despite what they're alleging, my client has suffered traumatically through this. She has mental health conditions, including, I believe it's a benign brain tumor, but she has substantial medical issues that she's been dealing with, and she's been predominantly in Alabama living there. But yet the proof of the miscarriage from an OB is not good enough to satisfy that. Nonetheless, we provided it multiple times, even with the date on it this next time, and that's not good enough. We've made half of the $12,000 payment, I think, or it may be paid in full, but payment has been made in full of $12,000. And if you recall, Judge, she also was found to have an arrest warrant stemming from all of the allegations that led to the TPO to begin with. When we found out about that, she turned herself in within, I believe, 48 hours. She actually went to the jail once, and because there was the shooter situation in downtown Atlanta, they turned her away. She went back the next day, turned herself in. She was released, Judge, and she was released with an ankle monitor on a misdemeanor stalking case. I have clients that have been charged with murder that do not have an ankle monitor. So she is now under monitoring. She is incapable of receiving additional treatment for some of her health conditions because of the ankle monitor that is on her leg, but she remains on monitoring. Yet here we are, Judge, and now they're asking for her to be held accountable and in contempt, I guess, for this alleged contact. Their evidence is weak. Their evidence is that someone has contacted Mr. Steinfeld, that someone has contacted his girlfriend. I think the allegation goes so far to say that it was at the direction of my client, Ms. McMahon, and that is just absolutely not the case. Effectively, what has happened is that this consent TPO has now become weaponized. She has gotten calls at her place of employment and those calls have caused her to have interactions with legal and discussing the fact that she has been accused of these types of things. And so there's just a point, Judge, where Mr. Steinfeld has gotten his pound of flesh extensively, and at this point, it just becomes an issue of being litigious to be litigious. And so we are asking that you summarily deny this motion for contempt, and allow the TPO and the criminal case to continue to take its path through the justice system.
Did I put the ankle monitor through the paid for by the county?
You didn't put the ankle monitor on, Judge. If you recall, this was actually a condition of bond set by Judge Law at the misdemeanor bond hearing.
Is it paid for by the county?
No. Well, hold on. Ms. McMahon, you pay for it, correct? Yes, Judge. So she's on misdemeanor bond. She's paying for an ankle monitor while residing in Alabama, and while on bond.
Why don't you send to start with, why don't you send a consent? Who's the solicitor you're dealing with over there?
Judge, we filed a motion to remove the ankle monitor. She has medical conditions that prevent her from being able to receive treatment because she has that on. We have letters from her physician indicating that. So I filed that. It's in front of Judge Richardson already. So that's scheduled for, I think we got a notice of a hearing sometime in late June.
Well, they have those, which I don't know if the contract's worked out with state court. They have those, Ms. Settlers, y'all may have heard of these Talatrix watches. They're like big smart watches, kind of like Garmin watches, for that athletes wear. And they just look like big, huge Garmin watches. And they actually have a portion, an app that's connected so that Ms. Settle's client could have it, and it would show if Ms. McMahon had came with it. It won't show exactly where she's at, but it'll show if she comes within, I think, like a half a mile of where he's at. It's kind of, and I think it's about the same price. And I think state court may have it through their contract where it can be paid for by the state. So you may want to bring that up when you go there. And then that may relieve her of some, at least of that financial, because it's like what, $300 something a month. It gets pretty expensive.
We appreciate that, Judge. And, of course, we understand it's a condition of bond. It's just an issue of her health. It's not avoidance of it. And we would be fine with whatever alternative monitoring that allows her to get treatment for the medical condition she's suffering.
Yeah. And I think it usually makes it a little easier to treat, treatment instead of something on your ankle.
Your Honor, did I hear you correctly that you said that Mr. Steinfeld would also have access, not necessarily to her location, but whether or not she was within?
Right. There's an app. If you Google it or use the Googles, like my dad says, look on the interwebs. It's Talitrix. Talatrix. So it is. It's a big Garmin watch, that like where for running. Got GPS, all that. And there's an app that the alleged victim can have, and it shows if they come within so far. Won't show exactly where she's at, but at least he would know if she comes within a certain.
Right.
Right. And I think it still may be on the state contract. I forget, but if you call that number and ask them, they would also know. But let's okay. Hold on 1 second. I got somebody knocking. Hold on 1 second. Let me see that. Hey. Thank you.
Yeah, welcome.
What's the name?
I had to text you, I was like, don't shoot me. You got more on that. We got. Oh, man. I know you will. Is she like a? No. Ain't her job. I'm looking down. Oh. Oh, that one gave you. I told you I tried to steal them earlier, but your feet way smaller than mine. Oh, yeah, because we looking for that. Okay. We know you so well. Hey,
Don't always bring it in.
We hope there's water in there. I know anything sparkly, but there you go.
Nice, I love it.
Oh, yeah, because we just all.
Damn it, Truman.
Yup.
I want to know all the way, well, white t-shirt.
Yup. In my white tee. Look, in my white tee.
Let me see, I'm running.
Come on that road back home, you be like, look. So.
Thank y'all so much. Thank you.
Have you had that before?
No, you said it.
Oh, okay.
Thank y'all so
You're
much.
welcome, you're welcome.
Thank you.
I was gonna try to use your hand, see that might be. Try it out.
Thank you, guys.
Oh, yeah.
Trouble, this is perfect.
Oh, you don't trust anyway. Here. Don't mind me. I'm gonna tell my kid, it's opening harder than it normally is.
Yeah, it
Did
kept
that for
getting,
you too?
it got hung up before. Yeah,
Yeah.
it like got hung up. All right, sorry about that, guys. I did have someone give me a birthday gift, so I had to get it from when I came in here. All right, so is Miss, is it Mazine?
Mayenza.
Okay, yes, Miss Maria. Okay,
Mhm.
so she is whose witness?
Ours, Your Honor.
All right, let's go ahead and hear this. If everybody wants to raise their right hand. Steinfeld, man. All right, Miss Maria. Listen, man. All right, y'all swear affirm testimony about to give is the truth, whole truth, nothing but the truth. Nod your heads. Do you want to go ahead and go with Miss Maria, Miss Settles?
Judge, we'd invoke the rule.
Okay, but do you want to start with Miss Maria? So,
Yes, and then I can go ahead and let her go. I also witnessed Miss McMahon talking to somebody in her room, and I don't know who was in that room with her.
You don't need to show Miss McMahon. Is there anyone in the room with you? You got to unmute, but is there anyone in the room with you?
No, there's nobody in the room with me.
all right,
Okay.
make sure there's nobody in the room. You don't talk to anybody. And if you need to talk with Mr. Spiesman, how do you plan on communicating with him? Because if I see you down there doing this, I may think you're talking to somebody other than Mr. Spiesman. Is that how you're going to communicate with him? Is to text him?
Yes.
Do you have chat on your on your
I do
computer?
have chat.
On your
Okay,
computer?
if you do chat though, make sure you're not sending it to everybody.
Okay.
I'm just gonna we'll just use text messages, Miss McMahon, if we need to talk.
Okay.
about something.
You can text him. Miss Settles, I think Mr. Shoemaker wants the link.
I sent it to him.
Okay. All right. So go ahead, Miss Maria. You just said it, but I'll forget it. So go ahead, Miss Settles.
Is it Mayenza? Is that correct? Yes. Okay. All right. So, Miss Mayenza, how are you connected to these parties?
I'm dating Zach and I don't know Erin. I've never met her.
Okay. How did you and Mr. Seinfeld meet?
We met on Hinge,
Okay.
the dating app,
Dating app. Okay. And when did you start chatting on Hinge with him?
March 9th.
Okay. And you said you're currently dating. When did you first meet in person?
March 13th.
Okay. And did you exchange phone numbers at that time?
Yes, I gave him my phone number in person.
Okay. Not through the app.
No.
Okay. Has Mr. Seinfeld ever been to your residence before?
Yes.
Have you ever been to Mr. Seinfeld's residence before?
Yes.
Okay. And I'm going to, Your Honor, can I share my screen? Do I have that?
Sure.
permission? Okay. Okay. Can everyone see this plaintiff's exhibit 1?
Yes. Uh-huh.
Miss Maria, can you tell me what I am looking at here with plaintiff's exhibit 1? Can you identify this?
Yes, this is a text message I received on Thursday, March 30th.
Okay. And have you altered this in any way?
No.
Did you take this screenshot from your phone?
Yes.
Okay. Your Honor, I'd like to tender plaintiff's exhibit 1.
Objection, Judge, hearsay. I mean, who's this from? We have no clue who it's from. 974. It has to be an identifiable number, something.
Your Honor,
Go ahead.
Your Honor, I think that the context of the message will be able to identify who sent this message, and she's already testified to the fact that she received it, and it's from her cell phone number of what she received.
All right. I'll hold off on allowing it until she can lay a little more foundation on who it's actually from.
Sure. Ms. Mayenza, you received this message at what time or what date?
On Thursday, March 30th.
Okay. So this is after you had given your phone number in person.
Yes.
Okay. And this message, what does it say?
Says, hi, Maria.
Objection, Your Honor. Now she's reading hearsay. It's still hearsay. They've not identified that it came from anyone that's in court. And so thus it's an out of court statement.
That's all right. I can read it.
Your Honor, I can continue asking her about what the message says, but if it's going to be continued to be objected to, then that takes away my context to lay the foundation. So,
All right, go ahead and get some foundation on who it is she thinks it's from. Give her a little bit of leeway, Mr. Spiden.
Ms. Mayenza, what is this message about, essentially? Who?
It's about Zach, and it tells me to contact Aaron, and it threatens me.
Okay. Have you received other messages from random phone numbers, random emails
Yes.
that you don't necessarily know who those messages are from?
Yes, I've received a number of messages that follow the same text pattern and are from the same number spoofing app.
And are they all in reference to the same people?
Yes.
And did you receive these after the fact that you and Zach started dating and you exchanged phone numbers in person?
Yes.
Okay. Your Honor, again, I move to tender Plaintiff's Exhibit 1.
I'd object, Judge. It's hearsay. There's been absolutely no foundation. And all they've indicated is that they've received random text messages from random phone numbers and random emails.
I will only allow it in the fact that it's random people, but it's not identifying it as Miss McMahon at all.
Thank you.
All right, go ahead.
Ms. Mayenza, is this the first message that you received regarding them?
Yes.
Okay. Have you received other messages?
Yes.
How have you received those messages?
I've received 3 other text message threads, and then I received an email to my work email address, my corporate email.
Okay, now are they all in reference to Ms. McMahon and Mr. Steinfeld?
Yes.
Okay. Tell me about your day on April 2nd, Sunday, April 2nd. What did you do?
Sunday, April 2nd, I had a tennis match during the day. I came home, I showered, and then Zach came over to my apartment.
Okay. And on April 3rd, did you receive any contact?
Yes, I received 2 emails to my work email address.
And is your work email address available publicly?
No.
Okay. What were essentially the emails in reference to?
In reference to that I had spent time with Zach on Sunday.
Okay. Do you know anybody named Michael Wilson?
No. And I tried to look up Michael Wilson after receiving this text message, and I couldn't find anyone on social media. After receiving the text message for Erin, I could see that she had been previously looking me up on both Facebook and Instagram.
Okay. Who had viewed your profile?
Yes, that Erin had viewed my profile, yes.
Okay. Have you tried calling any of the phone numbers that you've gotten text messages from?
Yes, I called all of them, and all but one were from the Text Now number spoofing app.
Okay, and have you recorded any of those conversations that when you called, did you record it?
Yes, I believe I've recorded 2 of them.
Okay. Do you have that recording here with you?
Yes.
And if I identify it by a length of time for the phone call, would you be able to identify it and say whether or not that's the phone call you recorded?
Yes.
Judge, if this phone call has someone else's voice on it that's not my client, then it would be hearsay.
Ms. Settles?
It is a recording that goes to a automatic voicemail where you can tell that it's a spoofing app.
So then you're saying that it's Miss McMahon's voice on the voicemail?
No, it's not. It's an automatic
Uh-huh.
voice on the other side. It's like a robot essentially telling you that like this subscriber is not available or what have you, and it tells you what the app is.
I'd object to relevance, Judge. A automated voicemail that says that the individual is not available is somehow relevant toward prosecuting this contempt order?
Your Honor, at this point, Ms. McMahon is essentially able to skirt around the compliance with this order because she's been using random phone numbers.
Judge, I would have, this is not a response, this is objection. I mean, their conspiracy is precisely this, that everything that happens that is of random and arbitrariness is going to be attributed to Ms. McMahon. I understand that, but
not everything, Your Honor, that's random.
There has to be some foundation.
Mr. Spiesman, if I may respond, please.
So somehow are you going to link this voicemail to her?
Your Honor, it shows that this is the same app that has been used for all of the phone numbers that have been reached out to Ms. Menza and Mr. Steinfeld since this protective order has been put in place, when Ms. McMahon is very well aware that she cannot directly reach out to either of these parties.
But Judge, there still has to be some connection to Ms. McMahon here. I mean, I understand that these things are happening, and there has to be some verifiable connection for this to be relevant.
And Your Honor, I have text messages where Ms. McMahon has identified herself in other random phone numbers to Mr. Steinfeld with photographs of herself talking about their relationship. And it's again from a random phone number, which is again through the same spoofing app that is contacting Ms. Menza since the protective order has been put into place.
Is it going to be that same 678 number?
It's not the same phone number, Your Honor. I've got about 13 different phone numbers that are all from the same app.
Is it like a spoofing app?
Yes, Your Honor. That's exactly what it is. And I have tried to get those records from their legal department. I have not gotten them yet. They, in fact, need a subpoena court order, and I have not been able to get that. My understanding is that the police are working on getting those records through the criminal action. My understanding is that the police, in fact, have reached out to her, Ms. McMahon's employer, in order to get those records as well, to get keystrokes, I believe, to find out whether or not she's been searching this information. Your Honor, otherwise, there's no way that we can show it's Ms. McMahon because she's essentially going around the loopholes to show that it's her. And so this protective order becomes obsolete if she can just go and use spoofing apps, third parties, her employer, what have you, and still contact my client and these third parties that she's not supposed to be contacting.
All right, let's just see what you got.
I believe that I asked if I told you the length of time for that recording, you would be able to identify it.
Yes.
Okay, it's a 17-second phone call that goes to a voicemail. Is that the correct recording?
Yes.
Okay.
Yes.
Your Honor, I would move to tender plaintiff's exhibit. I believe I'm at 7.
You said 7?
Yes, Your Honor.
All right, let's hear it, and I'll give it the weight, if any, that it deserves.
Thank you, Your Honor.
The Text Now subscriber you are trying to reach is not available. Please leave your message after the tone.
And did you look at that Text Now app?
Yes, I did.
Okay. And have you looked into all of the phone numbers that you received text messages from, and they go back to this Text Now app?
Yes, and I contacted Text Now, and they said that they would remove the subscriber
Objection,
who
hearsay.
was sending me all of the messages.
Judge, hearsay.
Ms. Menza, you can't say what they said, but if you can continue your answer by not sharing exactly what they've told you.
I reported the messages as being threatening to Text Now, and they removed the subscriber.
Okay, so each of those phone numbers you've reported to Text Now.
Yes. Mm-hmm.
What other messages? Go ahead.
And then after the subscriber was removed from Text Now, I was contacted by another number.
Objection, Your Honor.
So you just can't say something someone else said.
She wasn't. Before Mr. Spiesman continued speaking over her, she was saying something.
Okay, go ahead.
After After I reported the number to Text Now and they removed the subscriber, I was then contacted again by text message from a different number spoofing app.
Okay. And you received, just going in timeline, so that we can keep some of this streamlined, you received emails, correct, to your work email?
Yes.
And what were those emails regarding?
I received emails regarding having seen Zach the previous day. I also received emails that someone used my name and corporate email address to sign up for multiple porn accounts.
And when you received those registrations for those porn accounts, were you called in by your HR?
I had to report it to HR, yes.
Okay. Did that cause you any issues with your employment?
I work for a very conservative company, so it was a very unpleasant conversation.
And you mentioned that you got other text messages. How recently did you receive those text messages?
I received some on May 5th, which was 3 days after the last hearing, and I received text messages on May 15th.
Okay. Have any of these messages been threatening to you?
Yes,
How have you felt when you've received those threatening text messages?
I've felt very scared. I've never been threatened by anyone before. And so I felt very scared. And I think that someone who threatens you, I feel like they would follow through. I feel like that's a line. To cross the line to threaten someone, you're willing to cross lines.
Are you aware of how your phone number would have been received or recovered from a third party?
No.
Your Honor, that's all I have for this witness at this time.
All right, Cross.
Briefly, was it Miss Mayenza? Did I get that right?
Mayenza.
Mayenza. Okay.
Mhm.
I understand, Miss Mayenza, that you have a theory as to who communicated these messages, but you would agree with me that at no point in time have you ever received direct contact from Mrs. McMahon from her phone number, from her cellular phone number, right?
I would consider these text messages to be direct contact from Aaron.
Okay, let's do this. Let's ask it a different way. Okay.
Mhm.
Has Mr. Steinfeld ever shared with you Aaron's phone number?
No.
Have you showed these messages to Mr. Steinfeld?
Yes.
Has Mr. Steinfeld verified that that's from a phone number that he had in his phone, namely Aaron's phone number?
I didn't ask him about the phone number. No.
So is the answer no?
I didn't ask him about the number. I
All
can't
right.
say.
Are you aware that Aaron has a Alabama prefix to her phone number, 205? You aware of that?
No.
Have you received any text messages or phone calls from a 205 phone number?
All the messages were from a number spoofing app.
So I'm really asking direct questions, if you don't mind answering. My question to you was, have you received a phone call or a text message from a phone number that has a 205 prefix? That's a yes or no question.
No.
Okay. All right. Have you received an email directly from an email account that is registered to Aaron? Yes or no?
I don't know who the email address is registered to.
I'm trying to ask yes or no questions. So if you want to answer yes or no.
Your Honor, I have to object. If she doesn't know, she doesn't know. I mean, that's
Yeah.
All right, you can answer a question, but when he asks you a question, the first answer out of your mouth is a yes or a no, and then you can explain.
Okay.
You have no unequivocal proof that Aaron is somehow related to this Michael Wilson, right?
No.
Okay. And are you aware of the type of relationship that that your current boyfriend had with Aaron?
Not really. No.
Okay.
Just high level.
Okay. All right. And are you aware that at one point she was pregnant with his child?
Yes.
Okay. And are you aware that she miscarried?
Yes. I'm aware that's what she said.
Okay. All right. And has anyone shown you the results from the OBGYN indicating that it was a miscarriage? Have you ever seen that?
No, I would be interested in seeing that.
Well, they've been provided to his lawyer if you like them.
Mhm.
And so is it fair to say that any and all communication that you've received from either, first off, a spoofed application or a spoofed phone number, correct?
Yes.
Or a email address that clearly is of someone you either don't know or someone that doesn't exist, right?
Someone who doesn't exist. Yes.
Or someone you don't know. I mean, a Michael Wilson very well could exist somewhere in this world, couldn't that person?
They don't have any social media accounts, which in this day and age, I feel like means they don't exist.
So, okay, if you don't have a social media account, your conclusion is that you couldn't possibly exist?
Your Honor, that's not what she's saying. She's answering his questions.
I'm trying to get to the bottom of why we're accusing Mr. McMahon of these acts, and what Ms. Manza just testified to is if you don't have social media, you don't exist. So therefore, Michael Wilson doesn't exist because she has no social media.
Well, and Your Honor, I mean, I'm extending I would appreciate extending some latitude here where my client has not yet testified to show the history of Ms. McMahon's doing this, because I'm trying to be conscious of my witness's time so that she can go back to her workday. And I am also trying to be conscious of the court's time that we only have until 1 o'clock.
All right. Go ahead.
If I'm to respond, Judge, I'm not interested in extending any latitude. None has been extended to us. It just is what it is. She either knows the answer or she doesn't.
Yeah, if she can answer it, she can. Go ahead.
So it's your statement that you're relying on the fact that she has no social media, and because of that, your feeling is that this must be a made-up person.
That is my feeling. Yes.
Okay, understood. Just 1 second, Judge.
Sure.
Now, before these strange things began happening, had you and Mr. Steinfeld ever spoken about his previous relationship with Aaron?
I had asked him why his previous relationship had ended. He answered something vague about them not being compatible. He did not mention that her name was Erin or anything relevant.
Okay, but at the point that these messages began coming in, I presume that he shared with you the extensive history between the two parties. Is that accurate?
Not until afterwards, not until I had received the message mentioning Erin's name.
Okay, but after you received that first message, you inquired as to who this Erin McMahon is and why she contacted me, right?
Yes.
And then at that point in time, I'm sure Mr. Steinfeld shared with you an extensive amount of information related to their prior past difficulties. Is that right?
I wouldn't say extensive. I mean, I didn't really care to know that much, but I got a SparkNotes version, a high level version. Yes.
Did he tell you that there was a TPO against her?
At that time, yes.
Okay. Did he tell you that he felt like she violated the TPO by contacting him?
No, he did not tell me that.
Did he tell you that he contacted the police and tried to persuade them to swear out some warrants against her?
After receiving the text messages, I contacted the police because I felt very scared, having been threatened. And that is when the police told me that he had a TPO and that it was a violation of the TPO.
Definitely wasn't my question.
Investigator Schroner told me that it was a violation.
Hold on. So here's my question. Okay. My question was, did Mr. Steinfeld tell you that he had contacted the police to ask them to investigate the allegations of harassment or stalking?
Not at that time, no.
Well, not at that time. Did you do it later?
After my police officer told me, yes. After
Okay.
Investigator Schroner told me.
Okay, so we ended up telling you all this information, right?
Yes.
Okay. Do you feel like you provided a pretty detailed overview eventually as to the prior past difficulties between the two parties?
Again, I already said I feel like I only know a high level. I haven't cared to know all the details.
Okay.
It's not really my business.
Okay. So it's your testimony. Y'all been dated for what? About 90 days?
Yeah.
Okay. And you're now being dragged into a contempt hearing to testify against my client, right?
I wouldn't say dragged in. I wanted to testify because I'm frightened.
Okay. And you've reported all of this to law enforcement,
Yes.
but it's your testimony that you only kind of have a high level understanding as to what's going on, right?
I mean, I don't know everything that went on between Zach and Aaron. No. I know a high level. I know enough details to feel satisfied.
Okay. One more second. I'm going to show you what's been marked as, let's see if I can share my screen here and do this right. This is Respondent Exhibit 1. You see that document?
Yes.
You see that name on top of that document?
No, it's pretty small. Is there a way
Your
to make
Honor,
it
I
bigger?
have to object. I mean, he hasn't even asked what this is.
Peach
How
credibility
does my client
judge.
have any foundation for this?
It doesn't. Peach credibility judge. It's a social media profile of Michael.
We
So
have no
what's-
idea who this person is. Miss Crick, whoever that is not here to testify from what I understand.
What's
Anyone
this,
could have made to this profile.
what's this video going to show?
Going to show the social media of a person with the same exact name as the individual, or the same exact first name as the individual that has been contacting Miss Mayenza, which demonstrates that it's not my client. So it goes to impeach her credibility.
Your Honor, it still has not been authenticated. Just because someone's name is Micah in the state of Georgia does not mean that it is the same person unless Ms. Wilson is here to testify to it.
The judge, frankly, it's the same type of evidence that we've heard on petitioner's presentation of the case.
Again, this woman is not here to testify to her own profile. Ms. Menza is here to testify to what she received regarding the parties.
Judge, you're cherry-picking evidence. I have the right to impeach her credibility at any point in time. She claims that this is an individual named Micah that has no social media presence, that doesn't exist. And I'm going to demonstrate that Miss McMahon has a friend named Micah that does have a social media presence, that does exist. And because all of this is circumstantial, every last bit of it, impeaching her credibility can be just as circumstantial as to all of the spoof allegations that we've heard to this point.
Let's see if she at least knows this person. I mean, I'll give it what little weight it should get, but let's see what's in here, if anything.
Ms. Mans, have you seen the social media profile?
No.
Okay. And
What is the name on the profile? Micah Crick?
Yep.
But the emails were from Micah Wilson?
I understand.
Okay. I just wanted to clarify. It's hard for me to see what you're sharing.
Okay. So is it possible that you received email correspondence from one of Aaron's friend that wasn't at her direction? Is that feasible? Could that have happened?
Your Honor, I believe that Mr. Spiceman is now testifying for my witness. She's already said she doesn't know who this person is. She's not seen the profile. She can't authenticate this.
I'll ask it a different way, Judge, but let's do it like this. Ms. Mayenza, you would agree that you're aware that the two parties, their breakup was, as I would describe, extraordinarily volatile, right?
Yes.
Okay, and you would agree that when there's volatile breakups, people take sides, people support their friend, someone they care about, right?
I think that there's limits to what you would do for a friend.
That wasn't my question. My question was, you would agree that when there's volatile breakups, friends support friends, right?
Yes.
Okay. And you would agree that it's likely that many of Aaron's friends do not think very fondly of your current boyfriend. Wouldn't you agree?
Yes, but how would they know about me?
I don't have to answer any questions, you do. So that being said, with that said, isn't it feasible that one of Aaron's friends might have contacted you?
Your Honor, again, I don't think that this witness can testify to any of this information that Mr. Spiesman is trying to get from her.
These are speaking objections. I mean, first of all, if she doesn't know the answer, she doesn't know the answer. But
Well, if you're asking, I mean, if you're wanting her to argue with you, I mean, I don't understand what the purpose is of your question.
the purpose of my question is an alternative explanation. I mean, that's exactly what we're here for, Judge, is whether my client contacted either Ms. Steinfeld or Ms. Manza in violation of the TPO. If there's an alternative explanation.
Right. But, Your Honor, Ms. Manza is not here to argue that point. She's received messages that she was threatened by, and they were directly related to Ms. McMahon's relationship with Mr. Steinfeld.
So I guess, ma'am, if you can't answer the question, you can't answer the question. If you don't know, you don't know.
Okay.
Is it feasible that someone other than Ms. McMahon contacted you? One of her friends?
I don't know.
You don't know. Okay. Just like you don't know who did contact you, right?
Someone who is aware of Zach and Aaron's relationship contacted me.
Okay. No further questions, Judge.
All right. Any follow-up, Ms. Settle?
Just one, Your Honor.
Okay.
Maria, did you look into the phone, the messages you received, were they iMessages or text messages? Do you recall?
They were text messages.
Okay, so they were not iPhone to iPhone, correct?
No.
Okay.
Or sorry, no, they were not.
That you are aware of, they weren't from an iPhone.
Yes.
Okay. Your Honor, that's all I have for this witness.
All right.
Nothing
Anything?
further.
Okay. Call your next witness, Ms. Settles.
I have Mr. Steinfeld.
All right. Go ahead.
Your Honor, I will ask if Ms. Manza needs to get back to work, would the court be willing to release her?
Absolutely. She can be excused. Thank you, ma'am.
Thank you.
All right, and Mr. Steinfeld, you've already been sworn in. And I do want to bring up, you entered this consent protective order on March 25th, 2023. Is that right?
Around that time.
Okay. Do you recall what Ms. McMahon was supposed to do when it came to the pregnancy test?
She was supposed to provide proof that she was not pregnant with my child.
Did the protective order say exactly what she was supposed to actually provide to you?
It did. There was a provision. I don't remember exactly what it says.
Do you have a copy of the protective order?
Judge, I would stipulate to the order as entered. I mean, best evidence would be the order. So I would just stipulate to the order as entered.
That's
Okay.
what I want to look at.
And you have a copy of that before you, Mr. Steinfeld?
I do.
Okay. And that order it has been file stamped and is in the record. And it say that she's supposed to submit to an HCG pregnancy test or provide other medical records from a competent medical professional to confirm she is not pregnant. Is that right?
With my child, correct.
Okay. And were those records supposed to be provided within 10 days?
They were supposed to be provided within 10 days of that date in March.
Okay. And did you receive those records?
I still haven't received proof that she wasn't pregnant with my child.
Okay. What have you received instead?
I received later than that 10-day period an image stating that she had been in an office for a miscarriage, but that was not dated and it didn't refer to me.
Okay. And it didn't provide you the blood test that you were looking for the paternity. Is that right?
That's correct.
Okay. And when did you say you received that?
It was after the 10-day period had elapsed. I don't remember the exact date. I think it was mid-April. April.
That you received that directly from Mr. Spiesman?
Mr. Spiesman emailed that I would not be allowed to see that. And I had to ask my attorney to see that image. But I did ultimately see that image. Yes.
Okay. And have you, what else was Ms. McMahon required to do action-wise in the protective order?
She was required to submit to the psychological evaluation, which she hadn't by the time we last saw you, Your Honor. She was also required to submit payment for the first half of the legal fees by April 1st, or she was supposed to certify them USPS overnight by a certain date, and she did not. It was late. It was a week late, and Mr. Spiesman emailed me asking me for my physical address, even though it's in the protective order after the date that the fees were supposed to be received. But I did ultimately receive a check from Aaron's father, and then I received the second half of those fees earlier than the other deadline, which was June 1st of this year. I've incurred other legal fees since.
So, and we'll get to that, but the psychological evaluation is what I wanted to touch on. At the time that you filed the motion for contempt, had you received the pregnancy test results, whether they were that letter correspondence or otherwise?
No, I have not received that.
Okay. At the time of you filing the motion for contempt, had you received the psychological evaluation that Ms. McMahon was supposed to complete?
No.
Are you aware if that has since been completed?
The psychological evaluation?
Yes.
A document was shared with me this morning that appears to be some sort of psychological evaluation.
Okay. And was that psychological evaluation done by a PhD?
I believe it was a doctor.
Okay. The doctor was in Alabama?
I believe that's what you told me.
Okay. And do you recall when that was received by your counsel?
Within the last week or so is my impression.
Okay. Are you aware if she has completed any other kind of treatment?
I'm not aware.
Okay. When you got this protective order, there was no evidence that was put into the court's record regarding what Ms. McMahon's contact was to you.
Aaron consented to a protective order and non-disparaging
Objection,
order.
Your Honor, with relevance. We're not here to relitigate a TPO that we consented to.
Your Honor, it's...
Let me finish.
Sorry.
We're here for violations of that protective order. So effectively, anything that occurred before that day would be completely irrelevant.
Your Honor, I would typically agree with Mr. Spiesman. However, in order to lay this context, which the court does not have because no evidence was put before the court at that time, and in order to lay the foundation that Mr. Spiesman objected to earlier, I have to go back briefly to show what was the cause for getting this protective order in the first place.
Okay, briefly.
Thank you, Your Honor.
May I finish answering that question, Haley?
Oh, yes. Sorry. Go ahead.
Your Honor, I have compiled 90 slides of PowerPoint evidence that are the foundation for the pattern of behavior that we're talking about here today. So I just wanted you to know that I would appreciate the opportunity to share the truth from my side of what I've been going through for the past 9 months or so.
And Mr. Seinfeld, that is why we are going back here. So you received text messages from Aaron, is that correct?
I've received text messages from Aaron from a number of phone numbers where it's very obviously in the texts Aaron.
I'd object, Judge.
Here.
I'd object if this is not, again, if this is not from Aaron, it is a theoretical guess as to who this came from. It's not relevant. There's no foundation.
Your Honor, again, Your Honor, the context of the message, the phone numbers are from a spoofing app. The contents of the message show that it is Aaron who is sending the message. And I have not gotten to the point where I've shared my screen to show those messages, but I can direct my client in order to get those messages.
All right, go ahead. I'll give you a little bit of leeway.
Thank you, Your Honor. Mr. Seinfeld, can you see these messages right here?
Yes, I can.
Okay. Are these messages that you screenshotted
Yes,
from your phone?
that's correct.
Are these messages that you received?
Yes.
Okay. In these messages, essentially, how did you find out that it was Miss McMahon sending you these messages?
She sent images of herself and told and answered my questions in first person, including information that no one else should have unless she's shared it with them, including claiming to be pregnant beyond the point when it appears she's told me that she had a miscarriage. Only she would know these details, in my opinion, and it's consistent with the social media posts that I found that would only come down when I informed Mr. Spiesman or my father informed Aaron's father to have them taken down, that they would come down. Facebook and Instagram never took down these social media posts. It was only after I communicated with Justin or with Aaron's father through my dad to have them taken down that they would come down. So it's clearly Aaron, in my mind, who's been doing all of this.
So I want to revert you back to these text messages. These photos that are in here that I'm scrolling through that are on these first 3 messages, are these photos of Aaron?
Yes, they appear to be.
Okay. And these messages, she sends these messages along with the message where she is referring to herself in first person, correct?
Correct. And where she's talking about the way that we interacted in the past.
And in your relationship?
Correct.
Okay. Have you altered these messages in any way?
No, I wouldn't do such a thing.
Okay. Your Honor, I would move to tender, I believe this is Petitioner's Exhibit 8.
I just asked, Judge, that you give them the weight they deserve.
Okay. All right. They're admitted, and I'll give them the weight that I found out that they need.
Okay. Mr. Steinfeld, you reached out to her, and this is in February, if I can see this date correctly. Is that right?
This was in February of this year, around the time that I was compelled to file for this TPO when I found a tracking device on my car that was registered to Aaron McMahon.
Okay. And these messages, are you talking about the pregnancy?
We're talking about the pregnancy, which she's leading me to believe, to the extent that it was ever legitimate, was still going on, when in fact, in the social media post that I just mentioned, she said that she had a miscarriage in January. So I don't know what's true and what's false. And I've found social media posts with text that...
Hold on.
Yeah.
You're getting too far ahead of me. Hold
Sorry.
on. Okay, so when you were texting on this random phone number, is this phone number starts with 470?
Throughout, yes, it starts with 470.
Okay, and as Mr. Spiesman indicated earlier, what is the phone number that you have for Ms. McMahon, or that you have had previously for Ms. McMahon, the area code for that phone number?
I believe it was a 205 phone number.
Okay, the Alabama?
A Birmingham, Alabama phone number.
Okay.
But I've been texting with Aaron. I had been texting with Aaron from a multitude of phone numbers dating back to this past fall. So it'd become common course for us to interact over phone numbers that were not the 205 number.
Okay. And so this is the 470 number, which is from Georgia. And in these messages, she refers to herself and her pregnancy, correct?
Correct.
Okay. And what does she say about her pregnancy?
Judge, I just object. I mean, we're here for a contempt, right? A violation of a TPO. This is all irrelevant. I understand the need to kind of try to make some nexus between these numbers and other numbers, but what the context of it is, and the pregnancy and what did or didn't happen, whether it's his child or not, that's not the basis for what we're here for right now. That's litigating nothing really, because it's not a violation of the law to say you're the dad or you're not the dad.
Where are we at, Ms. Settles?
Got it. What do you have a list of the phone numbers that you received text messages from?
I do.
Okay, in reference to the relationship.
Correct.
And all of those phone numbers that you have, do you recall how many there are?
Roughly a dozen.
Okay. And when you found out that Ms. McMahon had reached out to Ms. Mainza, how did you feel?
I wasn't surprised, because the last woman that I dated was also contacted by someone who
Objection, Your Honor. What
Objection.
relevance, and this is going to be so unbelievably far away to be able to be anything other than hearsay.
Your Honor, if I may.
Well, hold on.
No, you can't.
Your Honor, I will go ahead and limit my client to discuss the messages that were received by Ms. Mainza. So go ahead and tell us the reaction you had from when you received messages, when you found out that Ms. Mainza received messages.
I had the same reaction I had when the last young woman I was dating received
Objection, Your Honor.
What was that reaction?
disbelief, concern that all of my efforts to distance myself from this woman were not working.
And when you filed for this protective order, did you feel satisfied that you would have that protection?
I thought that I would.
Okay.
I don't feel I do.
And why do you believe that this protective order is not working?
Because the moment that I had the protective order, I felt safe. And then the next day, I found fake social media posts that were similar to the same as previous social media posts that had gone up. The ones that I mentioned were only taken down when I asked the folks I just mentioned to take them down. Maria was still contacted after the protective order. I wish I could draw a direct line, but all I can say is that she received these messages. Mary Elizabeth, the last young woman I dated, received similar messages, and I want everyone. Those messages can't continue to be received. It's my understanding that that's against the rules, and I just want to remove this. I want this to end. I want to be able to move on with my life. This has been extremely challenging for me and my family. It's impacting all of my relationships and making me question my reality. And I really need it to end. And I want to get my legal fees back and to never be bothered again on this front. It's been almost a year, and it's really hard to do my job, to live, everything's hard.
And so what are you asking from the court today?
I'd like for Erin to be found in contempt, to know that she can't skirt the rules anymore, and I'd like my legal fees back. And I'd really like, I attended the bond hearing, and I know I can understand if criminal is a separate situation.
Your Honor, irrelevant.
Bond hearing's different. Go ahead, Ms. Settles.
Can I finish my sentence or no?
No, you cannot. Okay, so at this point, you're asking for the attorney's fees to be Ms. McMahon's responsibility. You're asking for her to be held accountable for her willful failure to comply with the court's order, and you're asking for this court to make her well known that she cannot continue to violate this protective order. Is that correct?
Correct, and if there's a way to permanentize it, that would be helpful. And I'd also still like to know for a fact that Erin was never pregnant or is no longer pregnant with my child.
Haven't we gotten that she's no longer pregnant, Mr. Speisman?
We provided proof of a miscarriage, Judge. The only thing I'd state to the court is this. When someone miscarries, and I can speak from personal experience, there's no way to do a paternity test on a fetus if it occurs in the first trimester. So he's asking for a medical impossibility. We have provided a document that is dated from her OBGYN that says she miscarried. Again, it's remarkably concerning that we have to continue to relive that particular issue. I get the rest of it, but that particular issue.
All right. So she miscarried whatever or whomsoever child it was.
And Your Honor, that's understood. I believe at the time of entering into the consent protective order, whether or not the pregnancy whether she had miscarried or whether or not she was still pregnant or had ever been pregnant was a question, which is why I believe that the other medical documentation was allowed in the consent protective order. At the time that, and again, this is what we're trying to show, is that at the time of filing for a motion for contempt, none of the things were complied with that were supposed to have happened. Now, since we have extended the time, those things have been fixed. But my client still has had to come to this court in order to get that compliance. So
Sure. And where are we with anything else she's missing that she's supposed to do?
No, Judge, she's completed a psychological evaluation. I made it clear to Ms. Settles and to anyone that's asked that no one other than Your Honor and a medical professional is going to dictate Ms. McMahon's mental health treatment. I think it's fair to say she has the right to be treated by professionals of her choosing. This is obviously a fragile situation to begin with. And so with that being said, she's completed a psychiatric evaluation from what I reviewed and determined was a well-experienced and certified therapist, doctor. We've provided that. We've also provided the proof of miscarriage. We've also paid $12,000 to encompass and resolve all attorney's fees.
Mm-mm.
So I think that all that would be reasonably left to consider would be whether or not there's been enough evidence to deem a contemptible action. And after a brief examination, I suppose I can argue for that.
Your Honor, at this point, we are asking for this protective order to be permanent as well. And I think that
Has that been filed in writing? There's notice requirement in the statute. Has that been filed?
the motion for it to be permanent, no,
Yeah.
there has not been a motion that's been filed, but we are here, Your Honor. I believe that the actions from Ms. McMahon and also Mr. Spiesman disingenuously does not, this conversation has been had. And Mr. Spiesman, you recall from our pretrial conference, the discussion was that the doctor's name was supposed to be provided to me prior to her getting the psychological evaluation, not for me to say whether or not that doctor was correct, but we had discussed whether or not a licensed social worker versus a PhD would be able to do a psychological evaluation, seeing that she was already getting mental health treatment. However, that was not provided to me until Saturday when I received the psychological evaluation. Again, we're dealing with compliance here. And if she did not comply with what she was supposed to do, that is why my client is here filing this motion for contempt.
She didn't comply as far as getting it to you in a timely fashion?
Or completing it, Your Honor, and that's the point.
She underwent, Judge, she's been undergo, I mean, she is, look, Judge, I guess the best way to put it is a lot of the reason for the TPO and a lot of the reason for the harassing communications is the underlying mental health issues, as you can imagine. I mean, my client's gainfully employed. She comes from a great family. She has been suffering from some mental health issues. So she's been undergoing therapeutic and psychological care because of the what I perceive to be the orders of the court and the demands of the petitioner and opposing counsel. We completed another psychological evaluation. It was not necessary. She was under treatment, but it wasn't good enough for them. So we did it.
Is she following treatment now, Mr. Spiesman?
Yes, Judge. I would ask the court, they can inquire of Ms. McMahon about specifically the treatment she's undergoing.
Ms. McMahon, I can tell you this. I had this young gentleman in front of me one time, not sure what it was that didn't get through to him. I don't remember if this is one where Mr. Spiesman, you may have been on this one. He had met someone on a dating app, and I think they may be engaged in some adult activities a couple times and split up. And then he started texting the petitioner. This guy brought in 2-3 ring binders of just text after text after text after text, going about the gym where he goes, all this other stuff, and got in front of me. And I guess the public defender, he'd been arrested in DeKalb County. The public defender actually allowed that PD to come here and argue on behalf of the respondent, the TPO. Why I shouldn't make it permanent? Why I shouldn't hold him in contempt? So after I explained to him I was going to extend it, he had the nerve to ask me, but could he start going back to the same gym? Could he call him in a few more months? Could he call him in November? I made sure that I told that man that if the petitioner passed away before he did, and I found out that he went to the cemetery and put flowers on his grave, I was going to lock him up for contempt. So if that doesn't drive it home about what no contact means no contact, I'm not sure what does. Mr. Spiesman will tell you, I will lock you up so fast it will make your head spin. And it is not pleasant well, they're not down in Union City anymore. They're down here at ACDC at Atlanta Pretrial Detention Facility, but it's not good either. So what? He's moved on. Who cares? Let him move on. You are young enough. There are plenty of more people out there. So who cares? Big deal. Let Maria have him. Let anybody else have him. He can date anybody and everybody in this courthouse, and I don't care, and neither should you. You are young enough where everybody that you have so many opportunities ahead of you. But going now, have they proved that that's been you using those? What do they call them? What did I say it was?
Spoofing apps.
There you go. Yeah, that's just true. That they can find out, and I'll let you know this, Ms. McMahon, and Mr. Spiesman will tell you. If cops find out that it's you, because you have to put a credit card in and you have to do all that, even if you go buy some sort of card and you put cash up, they will find out that it's you. And then you're going to have to pay Mr. Spiesman even more money for an aggravated stalking representation, which means 10 years in prison. And Mr. Spiesman will do it. He's got kids that need to be put through college. So he'll gladly take your representation and pay you. And I'm assuming that's going to be a base of 10 grand at least for him to represent you in something like that. Whoever, Maria, who cares? Ma'am, there is absolutely nothing wrong. Trust me. I am all about some treating. If you have mental health issues, treat them. Like I said, we medicate in my house. Truman's on his own little medication because he's a spaz. You got problems, medicate. Every lawyer on here, Ms. Settles, Mr. Spiesman, after going through COVID, we all have something, anxiety, something, just being like and dealing with what we deal with on a regular basis. It's anxiety, it could be depression. We all have some sort of mental health issues, whether we want to admit it or not. Lawyers do, because we just absorb so much. There's no way we can. Steve Shoemaker on here, tons of them. We could list them. Page 1 through 482 of the DSM-4. He's probably got all of those, but we all have it. That's okay. Get the help that you need. Take the medication, seek the counseling, but let Mr. Steinfeld go. Look, he's not that big of a catch. Why are you so wrapped up in him? He is just a regular old looking guy. Nothing unique about him. But is he worth you going to jail for 10 years? Prison, 10 years. 10 solid years. Now, I don't know if that's you. My gut says it probably was you. But I can't go by my gut. I have to go with the law. But let me tell you something, ma'am. It's someplace I think I could do sua sponte and extend it for 3 years or extend it another year. I don't want to hook you up I don't want to set you up for failure. Ms. Settles, you want to extend it another year?
I would like for it to be extended another year, Your Honor. I would also like it to be clarified that it reaches everyone that is connected to Mr. Steinfeld, not just him and the regular language.
And I want to ask you, and Ms. Settles, if you'll send it to me, but Mr. Steinfeld, what I want you to do is file a contempt before you lock her up, because give me the chance to lock her up first. Before you let any other judge lock her up and charge her with aggravated stalking, give me a chance.
Understood, Your Honor.
Mr. Spiesman will tell her to take an Uber to the courthouse because it's like $20 a day to park across the street, and your tires, wheels are going to be gone, and your windows will be busted out, and it's not worth it. Ms. McMahon, listen to Mr. Spiesman. He's in front of me enough. He knows, and he will tell you I will put you in jail. He is the only reason I'm not putting you in jail today. Got it? Anything else, Ms. Settles?
Mm-hmm.
Your Honor, we also, we want to hear fees. We want to be heard on fees. Mr. Steinfeld has unfortunately had to incur quite a bit trying to get this to come forward today, and for Your Honor to essentially say and do what the court has done today.
Well, Judge, it sounds like she's
already paying what, 12,000, 15,000?
She did by consent, yes, Your Honor.
Judge,
but the contempt is a separate action, and we do want her to be found in contempt.
If she's not being found in contempt, Judge, there's no fees. And again, I mean, my simple argument is I understand what the evidence probably shows, maybe shows, but there is not any competent evidence that demonstrates that Ms. McMahon has in any way violated it. In terms of the the issues with the psych eval or the pregnancy test, I frankly think that they're just not satisfied that they can control how they're getting information or what they're getting. I don't think either of those are contemptible actions. And if they were, the contempt would be to ensure compliance. It wouldn't be to punish. And so I don't think that would be appropriate. I've also tried on numerous occasions to provide them with this information. I provide them with the psych eval or medical treatment. I apologize. I'm told that's not good enough. So we get the psych eval. I provide them with proof that a pregnancy was miscarried. That's not good enough. So then I provide them a letter that's dated with the OBGYN. They claim that it's not from the OBGYN. I mean, with all due respect, Judge, I'm not, this is not the one I'm going to lose my bar card on. So I'm fighting this uphill battle with this compliance issue. And then we have what amounts to a hearing that I just don't think that they met their burden on. And we have paid attorney's fees to the tune of $12,000 by consent.
And Your Honor, I have to disagree with what Mr. Speisman is saying. Mr. Speisman claims that his client has complied. She has not. The consent order was entered with Mr. Speisman representing Ms. McMahon. The expectations were set. The details of what she was supposed to be doing to comply with that order were set. And Mr. Speisman was involved in that at that point. So there should have been no question about what was needed and what was necessary. What she did find out, what she did ultimately end up providing, was still not in compliance, which is why my client still had to file this motion for contempt and get an attorney to come in and explain all of these webs and to make these points. And he's incurred additional attorney's fees to essentially get her to comply with what she's already consented to. So
Let me hear, what are your attorney's fees?
my attorney's fees at this point, Your Honor, I am at, let me pull it up.
Mr. Steinfeld, I didn't mean you were ugly, just so you know.
I didn't think that way, Your Honor. Thank you.
I think you got my point.
I get my looks from my dad.
Your Honor, at this point, not including today, I'm sitting at $7,752.
Judge, I'm completely opposed to any further attorney's fees. With all due respect, Judge, and I think what you've seen from this hearing is that Mr. Steinfeld just wants to litigate. He says he wants peace, but he continues to bring war. I mean, the reality is that whether he likes it or not, she is on an ankle monitor. She has gone to jail. She is provided documentation. It's never good enough. And I appreciate their conspiracy theory, but that is just what it is, a conspiracy theory. And now they're asking for $7,000 in additional legal fees when I've tried multiple times to resolve these issues. And specifically what I was told last night, when I offered a permanent protective order, literally offered it, which is a notice requirement and has to be filed and we have to receive notice on, but I offered it. They said, well, he just wants to be heard. Well, if you want to be heard, and that's out of attorneys' mouths, if that's what you want, you can't then come and say, despite the fact that all I want is to be heard, now I want you to pay so that I can be heard. And that's what we're dealing with. Attorney's fees have to be reasonable, and that's completely unreasonable.
Your Honor, they are not unreasonable. At $300 an hour, I am reasonably priced. I have tried absolutely my hardest to keep these fees down. However, my back and forth with Mr. Speisman about essentially what is supposed to be provided that has not been provided. He mentions the letter. There was no date on that letter. So I needed something to show me what was actually being provided. The treatment that he claimed that Ms. McMahon was receiving was prior to the protective order even having been entered. So I'm glad that she was getting that treatment, and I am a full supporter of that, but it's not what she was supposed to be doing pursuant to the protective order. The fees were late. Everything that was supposed to be provided was late. I would love for Ms. McMahon to just understand and for it to not be an issue. However, because it has been an issue, that is why Mr. Steinfeld has had to even file this motion for contempt. It is not just because he wanted to be heard. He wants to be protected. And this protective order has not essentially done that until he filed for a motion for contempt. And then Ms. Mainza's concerns actually are what caused the police to move forward, not Mr. Steinfeld's. So he's finally getting some protection, and he's finally before the court asking for that same protection to be enforced and to require Ms. McMahon's compliance and for her to be held accountable. And it sounds like the only way to do that, if she's not going to be thrown in jail today from Mr. Speisman, on behalf of Mr. Speisman, it needs to be that she understands financially that this is a problem.
Listen,
All right.
we're
Accountable for that.
$25,000 into this. We understand it's a problem, Judge. And Miss McMahon is effectively indigent now because of it. She's about to lose her job because of Mr. Steinfeld having a law enforcement officer or himself contacting her office, her place of work. So I don't know what the goal is. If the goal is to bury her under the jail and cause her to be homeless, we're getting real close. And so the need for attorney's fees, Judge, it has to be factored in that we paid $12,000 already.
And Your Honor,
Already. They choose to litigate. They choose to litigate everything. Nothing is good enough. A letter from me from an OBGYN. I've been told on multiple occasions from Mr. Steinfeld, total distrust. Total distrust.
Your Honor, again, this is not Mr. Steinfeld's fault that we are here. It is her noncompliance. It is her accountability. These are her actions. That's what keeps getting lost here.
All right, I tell you what, we'll go ahead and make her pay $2,000 in these fees. Just get me that order. But let me tell you what, Ms. McMahon. We come back. I will not be happy, and we'll be back in person. At least you will. Get the help you need, Ms. McMahon. No shame in that. I promise you. Absolutely no shame in that. All right?
And
Shoot me
Judge,
that.
related, I'm sorry. I don't mean to interrupt.
No, go ahead.
I was just going to say, related to the attorney's fees, Judge, we're just going to need a little bit of time. She is paying for this. Her father is no longer paying for it. He paid
I
for this
understand.
$12,000. So we just like reasonable time to do so.
All right, that's fine. And please reach out to and ask Judge Richardson or somebody about that Teletrix. Maybe that'll help her with employment, because it's just not so obvious. And if she has to have medical treatment, I think it's easier for them to take it off and things like that. So yeah, but check that. It doesn't seem to interfere as much as an ankle monitor. So I'm not sure what she's having done. I know something wrong with her. I think you said her head or something, but I think they could probably do something about that. I think it'd be much easier.
Okay.
So yeah, Teletrix, and ask them. And ask the people at Teletrix, if you look it up. I think the guy's name is Dan or Don. Ask them, because they could probably explain it to you more. And if so, probably should ask maybe that the state pay for that, and that way she can pay him and take care of those attorney's fees and things like that.
Understood, Judge. Thank you.
All right.